When companies have a breach, again and again, we see that they send out a sanitized notice letter downplaying the breach. This opens the door for plaintiffs' litigation. Many lawsuits now that plaintiffs' firms bring are surviving motions to dismiss. So the case does get to the discovery phase because the courts have pretty consistently found standing for injury to at least proceed to the discovery phase. If a company has downplayed the risk and there's discovery on behalf of the plaintiff's firm that then brings to light the failures of the company to protect people's personal information, it can be a public relations disaster for the company. Again and again, we find that companies completely mishandle private information behind the scenes, and that stands in direct contrast to the notice letter they send out to consumers when there's been a breach, that there's really no chance that anybody has their private information, that it's not accessible easily by the bad guys, etc., etc. They get caught in an awkward situation where the information that comes out in the discovery is in direct opposition to what they've presented to the public. It's something that needs to be considered from the get-go so the company can be honest about the breach with the public and maintain their public relations status in a positive way with consumers. You also have to remember in a breach there's a whole lot of other implications to it. There's obviously the consumer relations aspect, but also U.S. Attorney Generals from all over the country have been becoming much more aggressive and asking companies who have been breached for information about the background of the breach, how the breach happened. They're becoming much more sophisticated to the regulations and the company's failures. So a company then has to respond to U.S. attorneys from numerous states to provide this kind of information. So if they haven't been honest in their notification and what's gone forward publicly, and U.S. attorneys find contradictory information when they question which companies are required to respond to, it can also, again, create a very difficult situation in terms of liability for the company. Oftentimes, if companies have not followed through and implemented the policies that they gained PCI certification on, and they try and downplay the extent of the breach, when the discovery comes forward either in a plaintiff's case or through the PCI enforcement process, companies can often lose their PCI certification status if they have not done what they've represented to the public that they were going to do to protect their private information. Having policies to protect consumers' private information without implementation and enforcement is, again, a plaintiff's litigation disaster. It opens the door when companies have policies or procedures that they don't follow and they don't have a regular implementation process. Just like companies have a security guard at their front desk that should check IDs for every person that comes in, they also need to continue to make sure that the employees of the company, the IT departments are implementing the policies and procedures and that they're continually reviewed and trained. We invariably find in these plaintiffs' litigation, when we proceed with discovery, that companies are very, very sloppy. Sometimes you can't prevent the breach because the hackers are so sophisticated, but where the litigation lies is the failure to recognize that their systems have been infiltrated for months and months and months, and information that they don't even have properly logged in, so there's not even clear information about what the hackers have obtained. It's just kind of a free-for-all, and again, it's a litigation disaster for companies that have been breached. More on the, not so much that they had the breach in the first place, but the fact that they had no policy or procedure to identify the breach and to stop it from happening as soon as possible. I read a headline in the newspaper recently that identity theft breach is going to be the next Pearl Harbor. Any time now we could have a breach that is so significant that maybe shuts down our electric grid system that then is going to all of a sudden create a heightened scrutiny scenario where there will be a significant swing in the pendulum in terms of plaintiff's litigation. If there is a breach that is going to cause enough significant damage, you're going to see a very big shift in the law, which has already started to occur on an individual smaller breach basis. But companies need to be prepared. They need to have procedures and policies in place that they're implementing. They need to have a plan in place up front where if a breach occurs, how are they going to handle it? How are they going to get these notices out quickly? How are they going to find out what information was taken? How are they going to do the forensic recoveries to notify everybody? These are the things that have to be in place before the breach happens. And you can't do this with personnel in your company. You need an outside entity that's going to be able to help you manage this crisis, that has the bandwidth when the breach occurs to jump into action on very short notice and control the damage caused by the breach.